Introduction to GDPR. On May the 25th, 2018, the General Data Protection Regulation, GDPR, will become law in all European member states, including the United Kingdom. The United Kingdom, despite leaving the EU, will continue to sign up to GDPR. This will remain law. The new regulation will replace the Data Protection Act 1998, DPA. Currently, childcare providers, including childminders, pay a fee to the ICO, which protects them and their customers. The Data Protection Act 1998 was developed at a time the majority of businesses were still processing data via paper-based means. In today's modern society, most data is processed electronically. What is the purpose of GDPR? To protect the EU's laws surrounding data protection, to protect all EU citizens' data's privacy, and to reshape the way in which businesses and organisations across the EU approach data privacy. The EU's aim is to devise this new initiative as a living document so that the law itself can move with the way in which the future of technology dictates. Does GDPR apply to our childcare settings? If your childcare setting currently holds information which falls into the scope of the Data Protection Act 1998, then it will fall into GDPR. The principles of GDPR are identical to that of DPA, though the difference is that new accountability requirements. This is how your setting demonstrates how you are complying with GDPR. Let's now have a look at some terminology. Personal data. Personal data is where any information pertaining to a person or data subject can be identified either through indirect or direct means. Therefore, it is vital that you think about how you currently store and share the data that you have in your possession. Think about photographs, how you store and display them, names, how you store and display those, email addresses, bank details, social networking posts. What do you write and say about the children? Could a child or family be identified either through public or closed groups? IP addresses, personal addresses, business information. Then there's the sensitive personal data, which could include child's ethnicity, racial origins, religious backgrounds, medical information, dietary requirements. Such information can easily be used to identify an individual. So all we're saying here is any photographs that you've got, you may not put a name to that photograph, but can that child be recognised? Probably yes. Do you have permissions for that? Look at the names. You may use names, but you may not have photographs with that name. Can they be identified to another person? The same with what a child likes to eat, child ethnicity, anything like that. So basically what we're saying is that when you put something on a social media site and you're talking in a closed group which you think is personal to you and those members in the group, you could be talking about a child and what they like to eat and what they've eaten today. There could be someone in that group that knows exactly what you're talking about. So you really got to think about, do you have these permissions and should you really be talking about this in those groups? Data subject and data controller. Data subject means the person whose data is being processed. Data controller, the person who is responsible for determining the way in which personal data is processed. Data processor. A processor is responsible for processing personal data on behalf of the controller. The processing of information or data in simple terms means obtaining, recording or holding information. It also means where you organise, adapt, alter data, as well as retrieving, consulting or using information or the data. It also means where you disclose the information to third parties. This could be with other nurseries, health visitors or other professionals connected to your childcare business. You are responsible for the data that you destroy, erase or block. Do I have to follow GDPR? As you're aware, the current Data Protection Act can fine individuals and businesses when they are found to have breached the Data Protection Act 1998. The maximum fine that can be bestowed upon is currently set at £500,000. For childcare providers, including childminders, this is a huge fine. But for some larger global companies, this is a small price to pay for a data breach. This is one of the reasons why the new GDPR is coming. The fines set under the new GDPR are essentially in place to force all organisations to take the breach of data seriously, to force them into protecting the rights of the data subject. Under GDPR, any organisations that breaches the law will now face fines of 4% of global turnover or €20 million. The fines could result from something as simple as not having sufficient customer consent. Organisations and businesses can be fined also 2% of annual turnover for not having their records in order, failing to provide policies and to demonstrate how they are keeping data safe and with consent. GDPR, do we need to register and will there still be a fee? In simple terms, no to the first question and yes to the second. GDPR removed the necessity. Currently, as data controllers, businesses including childcare settings have to register with the ICO and pay a fee of £35 per year. When the new data protection legislation comes into force in April 2018, there will no longer be a requirement to notify the ICO in the same way. However, a provision in the Digital Economy Act means it will be a legal requirement for data controllers to pay the ICO a data protection fee. These fees will be used to fund the ICO's data protection work. As now, any money the ICO receives in fines will be passed directly back to the government. The Digital Economy Act paves the way for a new funding system for the ICO. The amount of data protection fee is being developed by the ICO's sponsoring department, the Department for Digital, Culture, Media and Sport, in consultation with the ICO and the representative of those likely to be affected by the change. The final fees will be approved by Parliament. The new system will aim to make sure the fees are fair and reflect the relative risk of the organisation processing the data. The size of the data protection fee will still be based on the organisation's size and turnover and will also take into account the amount of personal data that it is processing. What is the fee likely to be? Organisations should continue to renew their notification as usual, and it is still a criminal offence to not notify if an organisation needs to. Once the ICO know more about the new fees, they will be telling all organisations about the changes and what they need to do. So until then, new fees come in, it's very much business as usual, so no excuses for not letting the ICO know. If you look at Tier 1, Tier 2, Tier 3 and direct marketing top up, you will see that as a childminder or as a childcare setting, if your staff headcount is below 250, turnover below 50 million per year, and the number of records passing through your data control system is less than 10,000, you'll be looking at an ICO fee of £55. Again, just remember that these will be all confirmed after it passes through Parliament, and we'll all know where we stand by April 2018. Privacy by design. What is this? The ICO defines this as privacy by design is an approach to projects that promotes privacy and data protection compliance from the start. Unfortunately, these issues are often bolted on as an afterthought or ignored altogether. Although this approach is not a requirement of the Data Protection Act, it will help organisations comply with their obligations under the new legislation. The ICO encourages organisations to ensure that privacy and data protection is a key consideration in the early stages of any project, and then throughout the life cycle. For example, when building new IT systems for storing or accessing personal data, developing legislation, policy or strategies that have privacy implications, embarking on a data sharing initiative, or using data for new purposes. The ICO would like to see more organisations integrating core privacy considerations into existing project management and risk management methodologies and policies. How will this work for childcare settings? Training on data protection, using software which is designed to protect privacy, implementing policies and procedures and monitoring them regularly. Privacy impact statements. What is this? In layperson's terms, this means you must undertake a privacy impact assessment where you feel the types of processing that you currently do is likely to result in a high-risk breach to the rights and freedoms of the data subjects, the natural persons. Childcare settings should ensure that they risk assess the way in which they collect data by ensuring that data is secure and is not accessible by others, and that all consents are granted by the data subjects. Where children are concerned, the parents/guardians' consent should be sought. We will discuss this further on in the presentation. Do we need to undertake a privacy impact assessment? The ICO has developed a template which you can work through to decide whether or not you should be developing a privacy impact assessment. These questions are intended to help you decide whether a PIA is necessary. Answering yes to any of these questions is an indication that a privacy impact assessment is useful. You can expand on your answers as your project develops if you need to. You can adapt these questions to develop a screening method that fits more closely with the types of projects you are likely to assess. We have adapted the questions on the template to make them more applicable to the childcare industry. Let's begin. Does your business involve the collection of new information about individuals? Yes. Will your systems compel individuals to provide information about themselves and their children? Yes. Will the information about individuals be disclosed to organisations or people who have not previously had access to that information? Yes. Are you using information that might be perceived as being privacy intrusive? For example, the use of facial recognition or biometrics? Possibly not. Will your business result in making decisions or taking action against individuals in ways that can have significant harm on them? Probably not, but think about social media and how that can have an impact. What's been said, who says what, where's that going to go? Is the information about individuals of a kind particularly likely to raise privacy concerns or expectations? For example, health records, criminal records, or other information that people would consider to be private? The answer is yes. Will your business require you to contact individuals in ways that they may find intrusive or have not agreed to? For example, social media messaging, WhatsApp groups, emails? The answer could be yes. Data protection officers, what are they? Unlike with the existing Data Protection Act 1998, the GDPR has created a new role whereby each organisation and business, including all public bodies, must introduce a data protection officer. In childminding settings, this is the childminder. The data protection officer must have professional experience and knowledge of data protection law. You can, however, employ a data protection officer who you contract in to help you successfully implement your lawful duties. The duties include completing the privacy impact assessment where appropriate and where needed, maintaining a breach register, liaising with the ICO where such data breaches occur, and creating, implementing and updating the company policies, procedures and practices. The role of the Data Protection Officer. The Data Protection Officer must have authority and must be empowered in their role as the DPO. Their role is fundamentally important to the overall setup of the business. The DPO will report to the highest management person in that business. Childminders working alone must ensure that they fully understand their duties and legal obligations, and they can seek outside report from various bodies such as EYFS Resources, PACey, and of course from their LA. The Data Protection Officer will fulfil their duties according to the law of GDPR. They cannot be disciplined for carrying out their role or disregarded by peers or management if they do not want to do it. This is important, and as you have already been made aware, there are massive costs attached to this, if GDPR laws are ignored. GDPR should always feature in management monthly organisational meetings. Childminders can seek help from the EYFS Resources GDPR support group. Click to join here. Let's look at some of the other changes which will come into effect on the 25th of May 2018. GDPR has now increased the rights of the individual, and the individual now has the right to sue you, the data controller, for damages arising from any breaches of their data. Individuals now have the right to be forgotten, meaning you have to dispose of all data pertaining to that person. No ifs, no buts. If it's been requested, you do that. Individuals can also object to having their data processed. As childcare professionals, we also need to be aware that there is an increased liability arising from other data controllers. This is where data processors are the people who process the data on behalf of the data controller, in this instance, you. In childcare terms, this could be an online platform such as Baby's Days, Facebook, or any other cloud-based systems. Under the current Data Protection Act 1998, such cloud-based systems that were operated outside of your control were seen as processors, so no direct liability was placed at your door. This is now no longer the situation. Under GDPR, it will become legal practice to ensure that you have a formal contract or a service level agreement with your chosen data processor. For childcare professionals, we should start to think about the IT services that we use, such as web hosting, any online learning journal companies, including Tapestry, Baby's Days, Facebook. In terms of the website, we look at your chosen data processor, IT supplier. They must have met the minimum requirements and have the correct competencies and accreditations. If you use the one that does not adhere to such minimum competencies, this will result in you committing a criminal offence. Let's now look at the 12 steps that the ICO recommend in taking for you to prepare for the GDPR. The first one is awareness. The second, assess what information you hold. Thirdly, communicating privacy information. Fourthly, individual's right. Fifthly, subject access requests. 6, legal basis for processing personal data. 7, consent. 8, children. 9, data breaches. 10, privacy by design and impact assessment statements. 11, data protection officers. 12, international data transfers. Next steps, goals and objectives. Firstly, you should appoint a data protection officer. If you're a childminder, this could be yourself, or you could look at an outside agency providing this for you. Secondly, carry out an information audit. Then review your data protection policies and procedures and consider any areas where you might need to implement a privacy impact assessment, which will help ensure that your privacy policies and notices are robust. Then review your information security policies and update subject access request procedures. This then leads to ensure that data protection is a standing agenda item that will always feature on your review meetings, during management meetings, or in the area of childminders, network meetings. Module 1 has looked at the main changes that will affect UK businesses from May the 25th, 2018. Businesses, including childminding settings that already have clear and concise processes in place, as well as policies and procedures, will already be demonstrating excellent practices and will find the GDPR switch really easy. Module 2 will look at children and the GDPR.